Hey, a quick heads up for our SSA friends and anyone accepted during the shutdown. We're hearing that agencies might be violating the Rehab Act or not properly treating leave. Here's what the rules generally say. First, yes, when there is a lapse in appropriation, your previously scheduled paid leave is generally canceled. But if you're an accepted employee, meaning you're required to keep working, OPM tells agencies it can use workplace flexibilities like alternative schedules and telework for brief absences whenever they can. If that doesn't fit your situation, the agency can place you in a short furlough status for the hours you're out, or you can elect to use paid leave under special shutdown provisions. Furlough time is paid retroactively when funding is restored. But here's the part some folks are learning the hard way: AWOL hours are not paid retroactively. AWOL isn't a Marvel villain, some say, but it will defeat your back pay, but it could also lead to termination. It is disciplinary, so maybe it is a villain. Now, what's going on at SSA? Well, we're hearing union leaders say employees are being categorically denied episodic telework or short time off and then coded AWOL, even when people literally can't afford gas or parking. SSA says that's inaccurate and that it's following longstanding rules. We're not here to pick sides. We're here to help you protect yourself under the law. So I think there are two lanes to think about here. Lane one is shutdown flexibilities, telework, alternative schedules are being placed in furlough status for short absences with retroactive play later. The time that we would more likely help as a firm, lane two, is disability based rights. Our firm does a lot of reasonable accommodation work under the Rehabilitation Act, telework, schedule changes, short leave, temporary reassignments. Those can all be reasonable accommodations if you need them because of a medical condition. The agency has to engage in an interactive process and can ask for appropriate documentation, but it can't just slam the door on telework or invent hurdles that make it impossible for you or any other federal employee. So I think here are some moments when it's worth talking to a lawyer, maybe us. If you ask for telework or a schedule change because of a health condition and got a blanket no with no real interactive process, you were told no telework during the shutdown period, even though your impairment is documented, you were threatened with AWOL while or after requesting reasonable accommodation. Because of that, you're forced to produce a doctor's note for a single sick day in a way that conflicts with policy or your union contract. You asked to be placed in furlough status for a brief absence because of your disability, and management refused and coded you AWOL instead, or you're being disciplined for not reporting when paying for the commute would cause serious hardship connected to a disability and would be because of a disability. In this area, don't sleep on deadlines. What's happening to you involves discrimination, including disability accommodation. You generally have 45 days to contact an EEO counselors. Those deadlines are not paused. That clock usually starts the day of the act or the effective date of the personnel action. It can continue in some cases if there's a continuing denial, but miss it, you may lose claims you care about. So practical moves, I would put request in writing if it's disability related. Say I'm requesting reasonable accommodation, save the emails, AWOL memos, doctor's notes, keep screenshots of any denials. If any of this is happening to you, or if you're thinking about litigating or filing, we're happy to see if we can help map the path that makes sense for your case. You can reach us at www.attorneysforfederalemployees.com or the shorter link fedlegalhelp.com/firm. Your paycheck or career might be on pause, but your rights are not. So I hope this has been helpful. Thank you everybody for your support and take care.